5 p.m. Central Time. Reddy Neumann PC brings in immigration updates. Emily, now it's an election is in the horizon right now. Who is better? Is Trump or Biden? Who is better for business immigration? You have a clear one-line answer?
No. Of course, we're attorneys. We can never give a one-line answer. I think they both have some plus points and some minus points. Obviously, with the Trump administration, less immigration has been the plan from the beginning, and we've seen that through more difficult adjudications, more RFEs, more denials, wanting to change regulations. Really, the only positive that we've somewhat had out of the Trump administration is the electronic lottery of the H-1B, but that now has its own problems with the second lottery happening. Now with the Biden team, I think that we'll see more liberal immigration policies in general, but is employment-based immigration going to be the priority for them? I don't think so. I think they're more concerned about DACA, more concerned about asylum and refugee, dealing with the issues at the southern border, maybe changing tactics on the border wall and those sorts of things. Definitely I think they have on their platform dealing with the backlog specifically for Indian immigrants, so that would be a positive thing. But is it going to be something that's going to happen quickly? And is that something that he can do? It's got to be done through Congress as well. What are your thoughts?
Yeah, one main thing is that what I see, Emily, is that people think that Democrats are just, good people all the time for business immigration, but it may not be true, especially when it comes to Obama and Bush administration. I've seen a lot of difference between both the people. In fact, Bush was more favorable to business immigration. Also, when it comes to Obama, he's the one who deported more people compared to any previous administration. So there are some bad things that are coming out from the Democratic administration too. Just because a new government or the Democrats are going to come, don't expect that all the things are going to go away. The prior to date, the discrimination against the Indians has been there for a long period of time. It was there at the time of Clinton era. President Bush tried to remove it. President Obama tried to remove it, but they couldn't. Now, Obama administration did have a complete majority in the House and in the Senate. He could have done over the filibuster rule in the first 2 years of his rule, but he didn't do it. He keeps on complaining at the end that, okay, the Congress is not acting. What did he do? In fact, the Senate, which requires 60 votes, where Democrats did not add 60 votes at that point of time, did pass a bill with 65 to 35 with a gang of 8 that includes John McCain and some good Democrats in there. They passed the bill, but then the House blocked it because at the time the Republicans were controlling the House. But Obama administration could have done all what we are facing the problems right now at the time when he had the power in the first 2 years. Mm-hmm. Emily, what's going on in the second lottery system? How much percentage of the people got selected in the lottery?
Right, so the interesting thing is we started hearing rumors that they might conduct a second lottery, but still silence from USCIS. So USCIS never actually announced that they were going to conduct a second lottery. We just started getting random emails on Friday telling us to log into our My USCIS account. Once we log in, we find a few more selection notices, and those notices are telling us that from August 17th, yesterday, through November 16th is a new filing window, and you can file if you have been selected now. So we looked at all of the new selections in our office. It looks like maybe around 8, 9, 10% of those that were previously submitted and not selected the first time around are now showing up as selected this time around. Again, that's not based on any announcement from USCIS. They still have not shared with us what the numbers are from the initial lottery, how many petitions they actually received. This is just based on the attorneys in our office and kind of what we're reporting to give you a sense of how many more people may have been selected. So That filing window has opened as of yesterday, and you have until November 16th to file if you've been selected this time around.
Emily, on the USCIS furlough, they're saying that 3/4 of the entire immigration is going to be blocked out. And they're saying that the entire business immigration will be on hold. Can you explain more about it?
Yeah, so we don't know exactly how this will all go down. First, let me remind you that we may not even see a furlough. There's a chance that Congress will provide some sort of relief, or will talk the administration into fixing the problem or delaying it further like they've already done once before. So if there is in fact a furlough that happens, it is very likely that we will see delays. I think that's going to be the biggest impact. So I think that we'll still be able to file applications. USCIS will still receive them, but I don't think they'll have the manpower to actually process them. So they may just sit until they are able to overcome this furlough and bring employees back. And of course, those that have already filed and are pending right now, if they don't get approved in time before a furlough happens, they may get stuck and have to wait longer for approval. This is all kind of guessing on our part and predicting what we think might happen. Hopefully we won't even face this issue. Obviously Congress is planning to come back to deal with the U.S. Postal Service problems. They've got their own problems, so that is taking precedence right now. But as we get closer to August 30th, we may see some additional action from Congress on the USCIS front.
So Emily, we have seen some, I have seen some furloughs back in Clinton administration. That was in 1999 or 2000, but the furlough was not 3/4 of the things. This is an entire immigration, 3/4 of the staff is huge. And they're telling the entire business immigration is going to be on hold. I mean, some rumors though. What can people do right now? I mean, should they contact the congressman? Should they file the premium processing? What can they do right now?
Yeah, I would do both of those things. The first thing is we need to get Congress to act in order to save USCIS or ensure that these furloughs don't happen. So you can email your congressman's office or call them to ask them to support USCIS and ensure that a furlough does not occur. At the same time, if you have something pending that's eligible for premium processing, you may want to have it upgraded to premium. If you're planning to file something within the next few weeks, file it as quickly as possible and do so in premium if that's available, so that you can get a result before any furlough happens.
Emily, if the people are getting laid off, and right now in the pandemic situation, they can't go to the home country. Some of the home countries are not even allowing them to come in. There's a lot of restrictions on the travel right now. And it may not be very good for these people to travel in the airlines with 500 people sitting next to each other, very close to each other. No matter what kind of mask they wear, it seems to be very dangerous, especially it's against the advice of a lot of the healthcare professionals. What should they do? I mean, if they get laid off and they are an L1 or H1 visa, can they apply for the B2 visa?
Yeah, so remember you do have a 60-day grace period as long as your I-94 lasts for at least 60 days. So during that time you can be looking to change employers and file an H-1B transfer or file a change of status to any other type of visa that you may qualify for. If you're getting to that end of the 60-day mark and you still don't have something on file and you aren't able to exit the U.S., you may need to consider filing a change of status to B2, which is a tourist or visitor visa. You can file that application online on the USCIS website so that you get an instantaneous receipt number, which will show that you are lawfully in the U.S. and can remain here based on that pending application. You can normally ask for a 6-month stay. Hopefully, knock on wood, by the end of those 6 months, things will be in a better shape to allow you to travel
Emily,
back to your home country.
in the previous statements, though, you and I said that if the people want to convert back to B2 to H1, we said it may not be practical at all because B2 takes a long period of time. Is there any development? For example, if I lose the job, I apply for the B2 and B2 is taking a long time. Let's say I get a job after 120 days after I left the job and I already filed the B2. Can I file the change of status now from B2 to H1 and what are the results of it?
Yeah.
Previously, we made a statement saying that it's not practical. Is there any new developments on that?
Yeah, it's still problematic because although you filed the B2 timely, because it's not yet approved, you're not actually in B2 status anymore and you're no longer in H1 status. You're in between in a period of authorized stay, which is not the same thing as maintaining status to allow you to change status back to H1. So you're kind of left with two options. The first option is basically treat it as a late filing of an H1 transfer. Even though you filed the B2 change of status, you request nunc pro tunc that the job search took longer due to the COVID-19 situation and request USCIS to put you back in H1 status as if you never exceeded the grace period. Option two would be there's really three options, I guess. Option two would be to submit the receipt notice for your B2 change of status and try to request USCIS to adjudicate that application along with your change of status to H1B so that you can instantaneously change from H1 to B2 back to H1 all in one step and put you back in H1 status. I've done that recently. I had two cases in that very similar situation, filed them within days of each other. One of them it worked, the second one it didn't work. So there's no rhyme or reason to it. I think I just got lucky on the first one. The other option, if you have a valid H-1B visa stamp in your passport, you could have the new company file the H-1B petition requesting consular processing, meaning you're not trying to change your status, you're just asking for the petition approval. Once it's approved, you could travel potentially to Canada or Mexico and return back using your already existing H-1 stamp from your previous employer to get back into H-1 status.
Okay. So they can do it from B2 to H1B if they want to, compared to what we made a statement before.
Somewhat. It's got its problems, but it sometimes can be overcome.
So Jitendra from YouTube has this question. Let's go to question, and I need your attention as a discussion. This person is an L1B, and he got the lottery in the second lottery. I mean, the ones that conducted recently. Where about how much percent of the people got selected, Emily?
Somewhere between 8 and 10%, I would say.
He seems to be one of the person. He's an L1B, and he's applying for a H1B in consular processing. Though I normally advise people not to apply in the consular processing because they're not technically counted to the H1B unless the H1B is approved with the I-94 or if the H1B is stamped in the passport. So I don't know why people go for consular processing in this situation.
Well, I think it depends if it's the same company that filed the H1 as the L1 because you're running out of L1 time and maybe you have an approved I-140 that provides you the extra time on an H1.
So why not do change of status from L1B to H1?
You may have a spouse who's in L2 with an EAD. That's usually what my clients are concerned about, is their spouse being able to continue work as long as possible, use up as much of that L1 time as possible, and then they control when they convert to H1. That may not be as important now that we have an H-1B visa ban, where you may not be able to get the H-1 visa stamp until after you run out of L1 time, and what are you going to do in between? So you really have to weigh the pros and cons of how likely are you able to get the visa stamp when you actually need it versus the potential of your spouse not being able to work for a short period of time.
I'm going to lean more towards getting the H-1B approved in change of status because simply getting selected in the lottery is not that easy. And if this guy misses though, and there is some problem with either the consular processing or if the company that filed the H-1B doesn't want to cooperate to change of status, or if he loses the job, then he can't go for stamping. There are all many different circumstances. This guy who got the H-1B in the lottery right now is may never be on a H-1B. I mean, that's a big danger that he's facing by choosing the consular processing. So many times we see people not getting counted by choosing the consular processing because they missed out something or the other. So I normally would like to discuss the options thoroughly with the family, with the wife, with the spouse, and see if which ones you're going to pick in the long run. What is better? Is the temporary EAD card or permanent, lifelong getting counted toward the H-1B, especially if you have an I-140 approval?
Srinivas from YouTube wants to know why the visa bulletin has not been published yet for September. Yeah, it seems to be over the last several months it's coming out later and later, so now we're at August 18th and we still don't have it out. I don't think there's any particular reason for that because there is no deadline requiring the Department of State to publish this by a certain date. It's just been kind of, this is what we've come to expect by the 15th of the month over the years, but they have been taking longer. They've taken longer in recent months. So I don't think there's anything to really conspiracy theory behind it. I think it's just they're going to do it whenever they feel like they're going to do it.
Yeah, previously we used to get it anywhere between 9th and 13th. Nowadays we're getting anywhere between 17th and 21st. So hopefully, somewhere tomorrow or day after tomorrow, we're expecting the visa bulletin to come in, and we're expecting some good numbers in this one, especially for EB1. One thing though, in the last 2-3 weeks, we've been saying that the visa numbers might be changing in the next 8 months. We may see that in the October visa bulletin that will be coming somewhere around in September though. The reason is that the extra family-based green cards that were supposed to be granted to the family preference categories that have not been used up in 2020 will be given to the employment based, and that is going to come from October 1st of 2020. The year of 2021 for the USCIS starts on October 1st. So that miracle things that we are expecting might not happen in September, though we are expecting some movement of EB1, but the more movement of EB2, we're expecting that in the October visa bulletin, which is expected to come on September 20th around. Sandy has this question from YouTube. After getting an I-797B as an extension, can I file a non-protect though? The reason why you've been granted I-797B without an I-94 is very crucial though. The non-protect argument might have already been argued in the first extension, and maybe the immigration denied it. That's one thing. The second thing is that you may already be accumulating the unlawful presence, and you may have accumulated some unlawful status also. Those two things are very important to be considered if you want to use the non-protect argument. I may be very hesitant to use the non-protect argument for you though, because you already got the extension denied.
Sachin from Facebook wants to know if there might be reductions in denials or 221Gs if we have a new president elected to the White House this time around. Yes, that is a possibility that things might ease up a little bit. We do see there's always trends happening over time. Years ago, 221Gs started to become common again, and then they went away, and now they're coming back. Same with the denial percentages, the likelihood of petitions getting denied with USCIS. It's interesting because there's really not been changes in laws or regulations, but the interpretation of those has changed under different administrations. So with the new administration, you can expect changes in how they're interpreting things. They might ease up on some of these situations and make it slightly better circumstance.
Question that is coming on the H4 EAD delays though. A lot of people, H4 EADs are getting delayed. I know we have been contacted by many different people with regards to the H4 EAD. We used to have a court litigation process that's not there right now. You can check back with us on next week if there is any update on the H4 EAD. Right now, at this point of time, we are unable to help you out on the expediting the H4 EAD. Yes, we do acknowledge that because of the biometrics issues and other issues, COVID issues, there has been a lot of delay, but at this point of time, we don't have any solution right now. But check with us next week. We may have a solution because there are some things that are coming out in the court that may turn out to be in your favor.
Anshuman from YouTube has a spouse whose H-4 application is pending, and he recently received his EB-1A I-140 approval and wants to know if he needs to withdraw that H-4 in order to file the I-485. So it really depends on the situation. If her H-4 is pending because she needs an extension and the previous stay has already expired, it would be a good idea to keep that H-4. You may want to keep it anyways because it's helpful to have the underlying status of H1 and H4 maintained the entire time the 485 is pending. The reason for that is if your 485 ultimately gets denied for some reason, even if it's denied in error, if you're not maintaining the H1 and H4 status anymore, you could end up unlawfully present, immediately out of status due to that denial. So it really depends on the circumstances around her current status, when it expires, why the H4 was filed. Is it a change of status or extension, and whether you intend to continue your underlying status once the 485 is filed?
Question from Raj from YouTube is that, can I move for 1 year to India and come back as a multinational manager and apply for EB1? Can I port the date from EB2 to EB1? Is it possible? Is it advisable? It is possible, Raj, but is it advisable depends on a lot of different circumstances, though. If I don't look at your resume, if I don't look at your job position in India, if I don't look into any job position in here, though, to give you a general advice, the success rate is, I would say, is less than 20% to get an L1A and to get the green card. That's what I will say. But what if you are a Satya Nadella and then you went and you worked for Microsoft India and then you're coming back here? Of course, the success rate will be quite different than what I told you. So it depends on the circumstances. People think it's very easy to get an L1A. People think it's very easy to get an EB1 if they work 1 year. It's not that easy. I'm going to tell 20% success rate if I don't, in overall. Emily, what do you say?
Yeah, I would agree with that without knowing any information.
Yeah. So if I were to plan my life and move my family from here to India and then spend 1 year and then I'm coming back with a 20% success rate, would I do it? Would I not do it? So I do not want to take all these decisions by just one-line statements from the lawyer. I would like all these things to be reviewed. And then after that, I will make my decision. One thing is for sure, though, to port the date from EB2 to EB1 is an easy aspect. Assuming that if you get an L1 approved, if you get an I-140 approved in EBC, they will put, the chances of porting the date is almost there. I mean, there is nothing, very less possibility that anything can go wrong. But getting an L1A and getting an EB1C is not that easy as you think, though.
Gia from YouTube recently received the employment-based EAD card but hasn't heard anything about the green card interview yet and wants to know if the furloughs could affect new green card applications. So yeah, it's normal that you've received the EAD but still no interview notice. That's partly because of the COVID-19 situation. All of the field offices were closed for some time and are just now slowly reopening, so we're just starting to see green card interviews being rescheduled. I think we got a couple in the mail today that I saw. But if a furlough happens, absolutely. Unfortunately, I think the green card application will be delayed. I would expect that when we lose 3/4 of the USCIS officers, that will impact the field office's ability to conduct interviews. It will likely impact the service center's ability to review the cases, to schedule them for interview. So hopefully, a furlough does not happen.
I want to add a couple of things to Emily's statement is that when the green card interviews are coming, previously they used to come with a notice for almost like a month or 2 months. We're getting notices that your interview is scheduled next week. I mean, believe me. So be prepared for that. That's one thing that I want to be. We're also noticing the biometrics appointment that are coming out with less time in the notification. So please keep checking your mailboxes or your mail every day to see if your biometrics notification has come in. Now previously when the biometrics notification come, if you are late, they will still used to take it, but now because of the COVID situation they are not accommodating the people though. So biometrics appointment, you need to watch very carefully to see if you get it and then go immediately. One question that came from Rahul Sharma from Facebook is, everything GC has been completed, his priority date is current right now, he's been waiting for years to get the green card and they are not approving it. Rahul, if it's been a long time that you filed the adjustment of status, you can raise a service request, but we know that they are going to take a long time to respond. You have a chance of going to the federal court litigation. A lot of people think that it's going to be very costly to go to federal court litigation, especially our law firm has made it more accessible, more reasonable rate. I'm not telling that it's the cheapest thing that's available, but it's a very reasonable rate. Instead of going around and frustrated, getting contacting the congressman, raising the service request, which they say that they're going to respond in 60 days. When you contact them again, they'll say that they'll contact in 60 days. And it keeps on going on forever. It may be worth, Rahul, for you to consider litigating in the federal court. If you want to contact our office, the person who is in charge in our office, his name is Stephen Brown. He's the head of the litigation team, and he does a very good job. You can contact him, then he can evaluate the case and see if it's worth going to the court litigation.
Mudasir from YouTube wants to know if there are any delays happening from the Labor Department for PERM ETA 9089 applications. Nothing out of the ordinary. They've been taking about 4 to 5 months if they're not audited for the last several months. Have not seen many major delays on that right now. Kaushik from YouTube says his wife received her first H4 EAD card, and of course it's got a typo on it. The last letter of her name has been cut off. He wants to know if there's any issue if she starts working with that card. I probably would not worry about it. It's going to be more hassle to get it fixed than it's worth. With it just being the last letter, you've got her picture on there. I'm sure she's got a passport photo she could show to prove that it's the same person. It's quite clear that all that happened is the last name got cut off and it's not actually a different person. I don't think it's worth messing with it.
Yeah, it's going to take 1 year for them to get a proper card, if ever they get it. And by the time your EAD might be even expiring too. Emily, any comments on the projects with the governments with regards to questions that are coming out is that if it's an implementation partner and you have the federal government as the end, one thing is that the executive order has nothing to do with the state government, guys. It's only to do with the federal government. Now, if there is an implementation partner, and the end client is the federal government, assuming if the executive order comes out. What is the status right now? Can they still work right now? And what is the status 2 months from now?
Right. Yeah, so there is an executive order on that issue, but it doesn't actually change anything. So right now there's no problem with an H-1B worker working at an end client site through a contract or a succession of contracts that is a government, federal government entity. Now what the executive order does is it instructs each federal government agency, executive agency, to review their policies, look at how many people are foreign workers that are working on these contracts, and determine if any U.S. workers were negatively impacted by bringing in foreign workers for the project. All they're doing is reviewing. Once that review is complete, then each agency has to decide how they're going to act going forward. So they may decide, yes, we've reviewed this, we don't think U.S. workers were negatively impacted, we're not going to change anything. Or they might give a report back to the president with their recommendations for making changes. Or we might have a new president by the time all of this rolls around, and it might all go away anyways. So most importantly, nothing changes right now if you're working at a federal executive agency when you are a foreign worker.
Question from Sharad from Facebook. He has a question. With the furlough thing coming up right now, is it advisable to go with the advertisement before getting the prevailing wage document? Sharad, the furlough is not applicable to the Department of Labor. At this point of time, the Department of Labor have enough funds to go for at least 8 months, or more even actually. So the furlough is only applicable to the immigration, not to the Department of Labor, since prevailing wage and filing the labor certification around the Department of Labor, you don't have anything to worry about the furlough. Now, whether or not you want to go with the ads before prevailing wage is already been granted though, that depends on, sometimes the employer wants to rush into it. There are chances sometimes when the prevailing wage comes very high, the employer may or may not want to go. But sometimes people want to, filing the labor certification earlier is absolutely important for them. So they may want to run the ads, and sometimes the ads money might be wasted. Those are the considerations that you need to take into, but not the furlough.
Cristobal from YouTube recently got a request for evidence on the H-1B extension and wants to know, should I be worried? What's the rate of denial after RFE in our experience? So it is relatively normal these days. So, and this all goes back to a memo that previously allowed USCIS officers to defer to prior adjudications. That basically means that if the officer sees you were already approved for this status once before with the same employer and you've been maintaining your status, it's safer for them to approve the extension. That memo is gone, so now they look at every single application you file as a fresh application. Even if it's an extension and you've been in the same job 10 times, 10 years and have gotten 3 approvals already, now it's your 4th one, nothing has changed yet, now you're getting an RFE. So that is quite common right now. They're just second guessing everything. Now, what are the chances of approval after an RFE? That entirely depends on the strength of the petition, what occupation code was selected, what wage level selected, what the job description looks like, what the minimum education is required for the position, what your education background is, and what documents does the company have to submit. Are they going to get an expert opinion letter? What's the issue raised in the RFE? So there's just no way we can advise on chances of approval after RFE, because every case, it's very case specific. I do think there are some statistics out there that suggested that it is a quite high chance of denial after an RFE, but that doesn't mean you should assume yours is going to be one of the ones that denied. Some RFE responses, I look at them and say, well, it's obviously why this was denied. This is a horrible response and it should have been denied. So if you have a strong case and a strong response, you should be able to get an approval.
I have 2 questions, Emily, that I need your attention, and one is only discussion. I'm going to answer it in the discussion though. In the lottery, are we getting any more new lotteries in the past 2 days?
No. So Saturday around noon was the last I think most people saw any. I haven't received any since then.
Thomas Eli has this question that what can he do is, Thomas C has this question, what can he do anything to get it picked up? No, you can't do anything to get the USCIS picked up. There is nothing you can do. This Praveen has this question, and I'm going to tell the answer and correct me. He misplaced his green card, he requested for the replacement, they gave it to him on time, that's good. And now he found the misplaced green card. What should I do? I would recommend that you mail it to the USCIS and you write a note saying that I found this one. Send the old one, don't send the new one, because they may have a track record that your old one has been misplaced. And they will put a track record on that. So if somebody tries to use that one, they may be arrested. So, because according to them, it's lost. So Praveen, you don't want to use that lost one under any circumstances. So don't keep both the things, send it to them. Or do you advise just to destroy the old one?
I would send it back to them, I think.
Yeah,
That
okay.
way they know that you've done the right thing.
Yeah, so Praveen, it's better that you write a letter to them. I found it, send the old one, don't send the new one. Don't ever try to use the old one. You'll be in big danger, because if they find out that your record it's been lost and then you're using it, then they think that you are somebody else other than Praveen, and you fabricated everything, and that's going to be, you'll be in big trouble at that point of time.
Rama from Facebook wants to know about how much time it normally takes for an H4 and H4 EAD to be approved after the H1B has been approved. The H1 and H4 EAD were all filed together. H1B got approved last week. Of course, the H4 and EAD are still pending. So there are two main issues that determine how long it will take. The first is the biometrics. So if your application support center is still closed or is slowly reopening, it may take longer for your biometrics to be done. That can delay the H4 and the EAD application. And then the other thing to look at is the service center. The service centers are quite a bit different in how long they're taking to adjudicate an I-539 application. So it could be anywhere from 4 months to 12 months right now, depending on which service center you're at. So it's a long process.
Some person doesn't have the birth certificate to file, and will it cause any problem in filing the adjustment of status? There are some alternatives if you don't have a birth certificate. I've written an article on it on RN Law Group. Just type in as a birth affidavit, you will find that article. It has an alternatives. If you don't have a birth certificate, you can get a non-availability certificate, get an affidavits, voter card, ration card, Aadhaar card. There are a lot of different cards that are there in India you can provide, especially if you're from India. You can provide all those things to be an alternative for a birth certificate.
City from Facebook wants to know what happens if the H1B was selected in the second lottery, but the H4 EAD has expired. Can we resume work? No, not immediately. So the H1B in this second lottery is only going to be valid from October 1st at the earliest. So that would be the earliest you would be able to resume work if you don't get another H4 EAD in between. If the H1 process takes longer than October 1st, then you have to wait until it's actually approved before you can start working again.
Prakash has this question. I'm planning to move from company to company B from company A, but company A wants to rehire me after 3 months. Do I need to file an amendment? Now, if you move to company B for 3 months and you want to move back to company A after 3 months, you can move. However, I want to be very careful. Is this a layoff, or is it that you want to move to company B? If it is a layoff and then you're trying to move to company B and there is no genuine job opportunity at company B, I would be very worried about all what you're speaking about. But if you want to move to company B and then want to move back to company A, and the company A does not withdraw the H1B, that's fine. I don't see any problem.
Anoop from YouTube wants to know if filing the I-485 is mandatory for filing an H1 extension if the priority date becomes current suddenly. So it may be. So once your priority date becomes current, if you're in H1B status, you are no longer eligible for the typical 3-year extensions that you would get based on an approved I-140. You're only eligible for a 1-year extension of your H1. So depending on the timing, if your priority date has been current for 1 year and you still have not filed the 485, you're not eligible for an H1 extension at all unless you can show that you have good reason for the failure to file the 485. So yes, it can be mandatory to allow you to continue to extend the H1 beyond the 6-year limit, since you're no longer eligible for the 3-year extensions.
Raj has this question. I graduated in a 3 years graduation. Can I apply an I-140 in EB3? Yes, you can. There are provisions under the EB3 where if the position requires only 2 years experience, though, you will qualify under EB3 even if the position does not require a degree at all. If it only requires a 2 years experience, you would be qualified under the EB3. The labor certification doesn't have necessarily require degree to qualify for the EB3.
Anil from Facebook applied for the adjustment of status way back in 2012. It's been pending ever since, waiting for the priority date to become current. He got the EAD and moved to a new employer back in 2014. He's wondering, he thinks that if the USCIS sends a request for evidence asking for the new I-485 Supplement J, his new employer won't sign it and wants to know what other options there might be. I think your main option, if they request that document, you have to submit it with the employer's signature in order for that employment to count for purposes of AC-21 to allow you to get the green card based on this new employment offer. So if they're not willing to sign it, I think finding a new job is really your main option.
Uma has this question. My brother-in-law is a U.S. citizen. Can he apply to sponsor my son and my wife? Uma Dodi. Mr. Uma, yes, they can apply for your wife and son and also for you too. However, there is a waiting list of approximately 17 to 18 years for you to get the green card. And based on the I-130 application, what is required for your brother-in-law to apply, you cannot just stay in the country though. You should still maintain your legal status until the priority date becomes current. So it may not be practical for you to get the green card on that. If it takes that long, maybe your employment based might come a little bit faster too. Another thing that you need to be concerned about, Uma, is your son. Is he going to become 21? There are some concerns about it before the priority date becomes current. That is also a big concern for you that you need to worry about.
Swati from YouTube has an H-1B case that was received in June and recently upgraded to premium processing, received notification today that the premium has been received and wants to know how long it takes from here. So yes, generally from the received date mentioned in the email that comes from the premium processing unit, it's 15 calendar days from that date. So in about 2 weeks plus or minus a day or two, you should be getting the next update.
UK from YouTube has this question. I recently got an employer-employee relationship. Is this RFE legal based on the IT serve litigation and the compromise that happened with the USCIS? Yeah, employer and employee relationship can still be tested though. The documents requirement and certain things were being eased up with the recent agreement with the IT serve and USCIS. But it's not that there is no prohibition that the USCIS cannot ask employer-employee relationship. When you respond to the employer-employee relationship, you can provide the court litigation and the agreement that they had with the USCIS to defend yourself, but you still need to provide the ancillary information that they're asking. I would also provide them as much as information and then tell the USCIS that maybe they are violating their own rules and regulations, and then still request for the approval instead of just challenging them. You don't have any authority to issue an RFE at all.
Jude from YouTube wants to know, what are the odds of an H-1B extension approval if there's a change in the SOC code in the new application? So a change in the SOC code by itself really is not relevant to getting an extension approved. What is relevant is what is the new code, does it qualify as a specialty occupation, and do you have the education background necessary for that new occupation code? So just changing the code generally is not much of an issue as long as, if it's the exact same job and exact same job duties, sometimes the same job can fall under multiple codes, and it's the employer and the attorney's choice to decide which code to select. So if they're changing it to a new code, doesn't mean the old code was wrong. It just means they're using this one because they think now it better aligns with the job duties, and as long as that code is one that normally requires a bachelor's degree or higher in a specific field of study, and you have that degree, it shouldn't have any issues on the extension.
D from YouTube has this question. He has applied the labor certification in the month of May. How long it's taking to get a perm, and how long it will take to get the I-140 approval afterwards? It's taking approximately around 4 to 6 months to get the perm labor approved right now, unless there is an audit on it. Now, once the perm labor has been approved, the I-140, you can do it in premium processing or normal processing. If you're doing premium processing, you get the adjudication done in 15 days. But if you do in the normal processing, it may take anywhere between 1 month to 8 months, depending on the officer's load who got your application.
Jitendra from YouTube wants to know, for the second lottery selection this year, what would be the start date of the H-1B approval notice? October 1st or sometime next year? So although the normal rule is that you can file the petition up to 6 months in advance of the start date, which would suggest if you're filing November 1st, you should have until May 1st to put a start date. That's not how they're proceeding with this lottery. They're still requiring you to list October 1st as the start date, even if you're waiting until November to file. Now then, it will depend on when it actually gets approved. So if you're filing before October 1st, you're going to request an October 1st start date, and if it's approved before October 1st, the start date will be October 1st. If it's approved after October 1st, generally it's the date of approval, but last year we saw a number of cases where they actually backdated the approval to October 1st, even though it was approved much later.
Emily, I want some discussion on the day one CPT. This question comes from Kruti. She has an RFP on the maintenance of status for the day one CPT. How do you respond to it? Will you defend it? Will you ask for the counsel processing? What is better? What is not better?
I think it depends on a few things. Mainly is, are they questioning whether CPT was properly authorized because it was issued at the same degree level? If it's that type of RFE, we have not had any success in getting that approved. So
what are the negative consequences if I respond with the same degree level? I did a master's degree, let's say in University of Texas, and then I go to this day one CPT, and I have used up the OPT and STEM extension. Now I got the day one CPT. And they issue an RFE and I get a denial. Will I still get the H-1B approval? They deny the I-94. What are the negative consequences of it?
Well, yeah, you can still get the H-1 approved, but in that approval notice, they're also going to send a denial of the change of status that says we're denying it because we think you're violating your F-1 status. From the day of that denial, that ends your F-1 status, so you have to stop working and leave. You don't have a choice to continue to stay and complete your CPT. So by converting to consular processing, yes, you may be delaying your ability to get into H-1 status, but at least you can continue to stay in the U.S. after you get that H-1 approved in time when you can go for stamping.
So you would suggest the consular processing. Actually, the lawyer should have filed in the beginning the consular processing, though.
Agreed.
Tamsi has this question. We have filed L1A, L2, and EAD at the same time. What are the chances for all these three things to get approved at the same time? I would say nil right now. We haven't seen that. Since the time they started the biometrics in March of 2019, I haven't seen a single case where all three cases got approved on the same day.
Mm-hmm. Anam from YouTube wanted to let us know that you received his green card and that we've been a good stress reliever for him and giving the right updates, and he just wanted to say thank you. So congratulations. We're very happy to hear that you got your green card. Those are the kind of things we love to hear, and that's what we're here for. So great.
Arpit has this question. Can I apply EAD along with the EB1A I-140 application? Arpit, assuming that priority date is current, there are two circumstances. If first you may have a previous I-140 that has a priority date and you're porting, or maybe you are not from India or you may belong to other country, or if the prior date is current under either of the circumstances though. Yes, at the time when you file an EB-1A application, you can file the adjustment of status application, also called as 485 application. Along with that, you can file an I-140, along with the 485 application, you can file an EAD application though. Although, if you're filing an EB-1A, I normally recommend people to wait until the EB-1A is approved. The one reason is that you do have a premium processing in the EB-1A. Now, it's not there in EB-1C, it's there in EB-1A, because if you file an I-140 and you file an adjustment of status, you file an EAD, you file an advance parole, you'll be wasting a lot of money by any chance I-140 gets denied. But I would do the premium processing and get an I-140 and file an adjustment of status and EAD. But if to answer the question, is it legally possible to file? Yes, you can.
Sunmeet from Facebook wants to know about the latest information on the H-1B travel ban and the presidential proclamation. He's planning to have his wife apply for her H-4 visa in November or December. He's currently on H-1B, and he wants to know if he needs to be in the U.S. in H-1 status for her to apply for the H-4 visa, or if he can be outside the U.S. but has a valid H-1 visa. Either one of those is fine. So if you are in the U.S., we're in the U.S. on June 24th, the date of the proclamation, and you are maintaining your H-1 status, the proclamation does not apply to you at all, which means it also does not apply to your wife. If you are outside the U.S. but you have a valid visa stamp already for your H-1, the proclamation does not apply to you, which means it does not apply to your wife.
D has a good question and an easy answer for me. What is better, moving to H4 or B2? I have an option, I suppose, is on H1B. Simple, H4, not B2 at all. There are great advantages for H4, not many advantages for B2. So obviously H4 is the best option for you. Okay.
Lucky from YouTube wants to know, by when do the skills for the perm process need to be gained by the employee? Does it have to be prior to the coming to the U.S., or could it be while working for the same employer in the U.S. sponsoring the green card? So it really depends. Generally, the easiest route to take is that you gained those skills before you started working for the U.S. employer. So that could be with a different U.S. employer. If you came to the U.S. with this employer that's sponsoring you, then they would have to show that the job that's being offered to you on the perm is at least 50% different than the job that you worked in that you gained those skills. So it does become a bit more complicated, not impossible, but it needs the right circumstances to work.
Question from Mansi. Does the 6-year rule for the H-1B, is it applicable for the non-quota H-1Bs also? The answer is yes, Mansi. The 6-year rule is applicable for the non-quota too. So even if you move from non-quota to quota also, all the H-1B time will be counted though. The H-4 time will not be counted. All the H-1B, whether it's a non-quota or quota, the H-1B time will be counted. The 6 years is counted. If you want to extend beyond the 6 year, you need an I-140 approval. And just for those other people who want to learn more about is that if somebody moves from L1 to H1 or vice versa, the time period of the L1 will be counted to the H-1B, and the vice versa H-1B time period will be counted towards the L1, unless they go outside the country for more than 1 year, and there are some limitations to it to not count. But both L1 and the H1 time period will be counted together.
Manish from Facebook has an H-1 extension that was filed in the Nebraska Service Center about a month and a half ago and wants to know if you should upgrade to premium processing or wait. The I-94 is going to be expired by the end of October. I would upgrade to premium. Don't, because even if you wait, even if your I-94 is valid till the end of October and you've got time, you might end up with a request for evidence, and it's going to take time for your employer to gather all of the documents, make the response, and submit that. So you might be beyond October even with premium processing if you wait too much longer. So yes, processing times may be decent at the Nebraska Service Center, but why risk it? Get it over with.
Sarvesh has this question from Facebook. His wife, his H-1B is not stamped in the passport. Can his wife approach the consulate and apply for the H-4 visa? Is it legal? Perfectly. She can apply for the H-4 visa even though you don't have the H-4 visa stamped in the passport. She is legally eligible to apply for the H-4 and get the stamping and come back into the United States. Question that is coming about Ramakrishna Rajagopalan. Can we downgrade from EB2 to EB3? Is it advisable for people to downgrade from EB2 to EB3? This question comes up very frequently, Ramakrishna Rajagopalan. Yes, you can downgrade from EB2 to EB3. To downgrade from EB2 to EB3, though, with the same company, the good thing is that you don't have to file another labor certification. You can use the same labor certification and downgrade to EB3. Ramakrishna, we are going to release a video tomorrow in this Facebook and also in the YouTube. You may want to watch on that. That video is exclusively only on downgrading from EB2 to EB3. That is going to be good for you.
Sarvesh from Facebook wants to know if his wife can apply for the H-4 even if his H-1B visa isn't stamped on the passport yet. So I'm assuming you mean apply for the H-4 visa stamp at the consulate. That is possible. I'm assuming that you are in the U.S. in H-1 status. Perhaps you got a change of status from another type of category and just haven't gotten the visa stamped. If that's the situation, yes, it's not required for you to get the stamp in order for her to get the stamp. You just need to be maintaining H-1B status.
Manju has this question. What's the wait time for the GC sponsorship parents of the US citizen from India? Will it come under the F1 or F2 category? Manju, it depends. If the child is under 21 and unmarried, they come under immediate relative. There is no F1 or F2. They're always current. US citizen, spouse, children unmarried and under 21 and the parents come under immediate relatives, so you won't find any priority dates for them at all. But if the child is above 21, then they come into the category called F1 category. If they are married, US citizen children who are married, they come under F3 category.
Nitin from YouTube applied for an I-539 to extend his daughter's L2 status way back in December and has not heard anything. He wants to know if there's any concerns with staying in the U.S. For such a long period without having an approval. He has the L1A approved until December 2021. So as long as she has the receipt notice, she is in a lawful period of stay. She's legally allowed to remain in the U.S. The entire time the I-539 is pending, as long as it doesn't go beyond December 2021, which it should not. So no issues with her staying in the U.S. even after her I-94 expired, as long as that I-539 was filed timely before the current I-94 expires.
Satya has this question. Is there a premium processing available for L1A to I-140? I'm assuming that you're discussing about the EB1C category. The answer is no. The premium processing is not available for EB1C. It is available for EB1A, which is extraordinary ability, which is available for outstanding researcher, which is EB1B, but not for L1A to I-140 EB1C.
All right, well, I think we're out of time for today. Thank you so much for joining us. If we didn't get to your question or you'd like more detailed consultation on your question, you can always schedule an appointment with myself or Rahul or any of our attorneys here at Reddy Neumann by going to rnlawgroup.com. And you can also get the latest news through our newsletter by signing up at rnlawgroup.com or immigrationgirl.com.
Thank you guys for tuning in.